Welcome to another episode of Judge for Yourself. The country's patent laws, it is argued, are keeping cheap generic medicines out of South Africa. Various health organisations say that our intellectual property laws permitted drug companies to get patents and then extend them beyond a standard 20-year period. A study by Yale University found that in 2008 alone, South Africa issued 2,442 medicine patents compared to Brazil, 273 over a 5-year period. Advocacy groups have been calling upon the government to tighten the laws and to test patent applications far more thoroughly. The Trade and Industry Department admits that the application process has been open to abuse and recently published a new draft intellectual property policy. To discuss this very critical issue for the provisions of medicines and other issues, we joined in our Johannesburg studio by Macdonald Netshitenzhe, who is the Director of Policy in the Department of Trade and Industry, and Louw, Executive Director of the Free Market Foundation. In Cape Town, by Louw, a Senior Researcher from the Treatment Action Campaign. But before we commence, I want to play you the following.
We've been accessing linezolid through the public sector for 2 years. We have 16 patients on treatment. We would have many, many more patients on treatment if it wasn't for the fact that linezolid is so expensive. It's 600 Rand per tablet, and the patient takes 1 tablet per day. So for us to treat, MSF to treat 1 patient for 6 months, it's 123,000 Rand. And the reason why it's so expensive is because one drug company, Pfizer, holds the only patent on linezolid. That patent is supposed to expire in 2014, but due to a process called evergreening, Pfizer now has secondary patents, which means that they could extend their monopoly until 2022.
Now, before we commence, I just want to say one other thing. We did invite the pharmaceutical companies onto this program. They say, no, there's a debate going on in relation to the policy. They'd prefer to debate it that way. I regard that rather unfortunate. I think they should be here and they should be accountable and they should be debating these issues, but we're going to go ahead notwithstanding. Macdonald, let me start with you. Are you going to tighten up? Is the proposal to tighten up patent laws?
Tightening up may be a strong word.
Well, how would you describe it then?
We would like to see to it that what is happening in agriculture and the food sector, veterinary, what is happening in the health sector, in the trade and industry, in the trading principles, there is a harmony. Government is talking in one voice. We are running one government.
But what's the voice? That's what I want to know.
The voice, in particular, in the health sector, we would like access to medicines, patent flexibilities, and the Competition Act enforced vigorously.
And are you telling me that we should just allow the market to do this, but then you shouldn't have patents?
You wouldn't have me here if that's all I was going to say. So
but that's what you generally say, so what are you going to say now?
No, I'm going to say something more. That is that we need to understand, for example, we heard from Doctors Without Frontiers that the reason a particular treatment costs a lot is because of the patent. But she didn't add the reason it exists is because of the patent. So in other words...
Oh, come on, Leon. I mean, how many years do you want these patents to go on for?
We can discuss the time, but let's understand that if you want people to invest in and develop patents over time, it's dynamic, not static. You don't look at what is now on the market and how can we get it. You look at how do we get people to develop treatments for our diseases, developing country or third world diseases, which have been hugely neglected. And one of the messages you want to send to the people who innovate, since governments worldwide have failed to do so effectively, private companies, is you want to say to them, please develop treatments for our diseases instead of developing treatment for esoteric diseases in the first world. And the way to do that is to say, we promise you that we will protect your rights and even better than the first world.
And so you can charge an excessive price?
Well, the word excessive is your word, and there's
well, it's
no
a word that comes from the Competition Act. But let me put it differently then, that you can charge...
It has no coherent meaning.
Okay, well, yes, it does have, because if you're the only person who's got that drug, you can charge whatever price you like.
If you want to sell me that pretty red tie of yours, you can charge whatever price you like.
No, but you can go and get your rather lousier tie and you maybe prefer that one. That's the problem. But you can't do that with the medicine. It may be the only medicine.
If you are Beverly Sills or you are Tiger Woods or you are Oprah Winfrey, you have a unique monopoly over your product and you charge what you like for it. And the only way the poor people of the world can get access to it is to respect their rights.
Okay, I want to just bring in Marcus. How do you respond to this?
Yeah, there's a number of things to respond to there. Firstly, the patent system has not been very good at delivering new treatments that are needed in the developing world.
Why do you say that?
For example, if you go to a clinic to be treated for TB today, you'll be treated with a combination of 4 pills that are all more than 40 years old. So the profit motive isn't a great way to incentivize treatments for poor people's diseases. That's the first point. But secondly, I think there's a misrepresentation here. Nobody, not the DTI in the policy document, and certainly not the TAC or Doctors Without Borders, nobody's talking about doing away with patents altogether. That's simply not what this is about. The issue is whether we grant secondary patents. So do we grant patents for simply reformulating existing medicines? Do we grant patents for simply using existing medicines for new uses? And we say we shouldn't, and international law, in terms of the TRIPS agreement...
But can I just press you, on this? Sorry, I just want to press you on one thing. I'm going to come back to that. It's an important distinction you make between, if I could call it, the primary patent and the secondary patent. But we'll explain that in a moment. But let's just take what Louw said. In fairness, what he says is we should be saying to pharmaceutical companies, you start innovating for new drugs for us, for our conditions, specifically for developing countries. And if you're going to give them the impetus to do that, you have to do it by way of giving them an extensive patent so that they can get a return. That's, as I understand, his argument. He's nodding, so I've got that right. What do you say about that?
That is fine. If companies develop new effective TB treatments, they should be granted patents for that. The one caveat is that if they price that medicine at such a high price that no one can afford it, then government should have mechanisms in law to force that price down. The government should be able to issue compulsory licenses, which allows...
But wouldn't that subvert the process in the first place? And how do you determine what an excessive price is?
Well, it's not only excessive pricing. International law that governs these things clearly sets out that countries can decide in public emergencies where access to a treatment is limited. Also when a patent blocks the development of combination pills or pediatric versions. So there are various criteria in international law that we are allowed to use to judge whether compulsory license.
I'm sorry to interrupt you. I have to take a break and then we'll come back. I know my guests here also want to respond to this.
News that moves. ENCA.com.